Can we have now Atty. Diokno to have the floor? It is a settled doctrine that Congress has the plenary power to legislate, subject to several constitutional limitations such as the Due Process Clause. You are assailing Section 4 of the Act for being violative of your right to due process. Which provision of this law is so unclear and ambiguous?
Section 4, if Your Honor, please, contains the definition of terrorism. It is our submission that that definition violates overbreadth, void for vagueness, and as well the strict scrutiny test. We submit, Your Honor, that the strict scrutiny test applies in this case because this law regulates speech based on its content. We are referring to Section 4 in relation to Section 9, Sections 5, 6, and 8, and 10 as well of the anti-terror law.
When we have already the IRR, and the IRR says the law punishes conduct coupled with nature and intent. Is
Your
that
Honor,
not a curative thing that will explain at least the big ambiguity in the law?
if that were inside the law itself, it may, Your Honor. However, the fact that it is only in the IRR and not in the law itself cannot cure.
Can you read the law? The law, I think, is acts, nature, and content.
No,
Context. Is that not included in the law?
the
Acts plus nature and context.
law, if Your Honor, please, refers to specific acts intended to.
But the law also mentions nature and context. Purpose.
Nature, yes.
I think the law mentioned that.
in
it's
relation
not-
to the purposes, Your Honor, that is correct.
Okay, can you make it clearer that the IRR did not explain the ambiguity in the law?
Well, we submit that statement in the IRR that the law
Explain
only
it in-
penalizes
explain-
conduct and not speech is in error, Your Honor, please.
Okay.
The
So
law
you-
itself clearly penalizes and restricts speech based on its content. That is found in Section 9, inciting to terrorism, Sections 5, 6, 8, and 10 on training, etc. Your Honor.
Based on Section 4, advocacy, protest, dissent, stoppage of work, industrial or mass action, and other similar exercises of civil and political rights, if not intended to cause death, blah, 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 are not punishable. Does this fall under the definition of protected speech?
That is precisely the problem, Your Honor. It has a collatilla that the exercise of these rights is not terrorism if it is not intended. And one of the problems with that, Your Honor, please, is we will leave it to the law enforcer to decide whether these exercises of rights have the requisite intent. Now, if Your Honor, please, the intent that was found in the anti-terror law is not the specific intent found in the revised penal code,
Okay.
because this is a special law. We are only referring to general intent, which is supposed, according to jurisprudence, presumed from the acts. So in
How-
other words, any law enforcer could presume the intent of a person exercising his rights and say that that is intended to endanger persons' lives, etc., and therefore qualifies as terrorism.
Further, Attorney Diokno, how do you consider this law? Is it a malum prohibitum or a mali inse law?
Well, it is a special law, if Your Honor, please. It is not a revised penal code law. In that sense, it is a malum prohibitum.
So it's a malum prohibitum as far as you're concerned.
Yes, Your Honor. Unlike, if I may point out, unlike the Human Security Act, which expressly incorporated Book 1 of the revised penal code, the anti-terror law does not mention at all the revised penal code.
Who bears the burden of showing presence and absence of intent? Is it not the government? According to the law and to the rules?
Yes, Your Honor, but the problem with this particular law is the fact that it includes in its definition exercise of civil and political rights, depending on the intent. Who will now decide whether that intent is present? Initially, it will be the arresting officer. Later on, it will be the prosecutor, and later on, it will be the judge.
So it's,
However, if I may, I'm sorry, Your Honor,
okay.
we would have no problem if the law required a predicate crime or criminal acts. However, the law does not. It did away with the requirement of predicate crime found in the Human Security Act. And therefore, intent may now be presumed from innocent, legitimate, non-criminal acts. And that is our concern, Your Honor, please.
Okay. If the government is able to prove such intent to cause damage, so and so, do you not agree that the act can be punished as terrorism?
We would have we would,
Remember, it's the government who will prove intent to cause damage, bodily injury, damage to critical infrastructure. Can it not be punished as an act of terrorism, falling under 1, 2, 3, 4?
precisely, Your Honor, the fact that that intent is simply presumed from acts that are non-criminal means that the law covers protected speech and conduct. As I mentioned in my opening statement, conduct, for example, that would be reminiscent.
Is it hard to prove intent?
I'm sorry, Your Honor.
Is it hard to prove intent?
Well,
Criminal intent? Is it hard to prove?
General intent found in the special law, no, Your Honor, because that is presumed from the acts. Generally, that would be presumed from a criminal act, but in this case, the acts are not criminal.
Since, according to you, it's malum prohibitum, the act, there is presumption of intent by committing the act?
Yes, Your Honor.
Okay, thank you. You are aware of the case of Brandenburg versus Ohio.
Yes, Your Honor.
The Supreme Court held that the state cannot forbid political speech that seems to advocate overthrowing the government unless it is both directed at inciting such action and is likely to actually incite it. In line with this test, consider this example. A social media influencer tweets to his 1 million followers that they must overthrow the current government by bombing Malacanang. However, this influencer did not actually commit any act. Can this statement be punished under Section 9 for inciting to terrorism?
The problem with Section 9 of the law, Your Honor, is that it does not incorporate the requirements of Brandenburg. The Brandenburg decision requires two elements for there to be a punishable advocacy: that the language is directed at inciting imminent lawless action and that it is likely to do so. That is not found in the law, if Your Honor, please. While there was an attempt by the implementing rules to include that, that is an essential element that should only be made by Congress and not within the province of the Anti-Terror Council.
So you will explain to us that the requirements of the Brandenburg versus Ohio case are not met?
Yes, Your Honor.
Since the petitioners argue that Section 9 of the ATA is unconstitutional for creating a chilling effect as regards the right to free speech and expression. However, there are several provisions in the revised penal code punishing inciting to commit certain acts, like 138 and 142. How do you differ this Section 9 from the provisions of the revised penal code?
I believe Your Honor is referring to the provisions on inciting to sedition.
Yes, yes.
Yes. Well, the purposes found in the elements of inciting to sedition are different from the elements of inciting to terrorism.
Here.
Yes, Your Honor. In fact, in the case of Escuelas, there was a dissent by one of the justices in that case.
What would be the difference?
Well, the sedition is really removing of allegiance, resistance to state authority. That is my understanding of that crime, Your Honor, please. And so far as terrorism is concerned, we are unsure ourselves of what given the nebulous definition it is really targeting.
Thank you, Attorney Diokno.
Thank you.